This is We the People News. Educational purposes only. Not attorney, cannot give legal advice. Alright? My opinions at times. No more, no less. Alright? Arm yourself with knowledge. Use that Second Amendment. And let's finish this story out.
Not just the ones who look like them. The terrible legacy of Plessy versus Ferguson cannot be overstated. It gave the constitutional green light to Jim Crow, a brutal system of racial apartheid that dominated the American South for more than half a century. It led to segregated schools, hospitals, buses, and neighborhoods. It created a society where black citizens were systematically denied their right to vote, to get a decent education, to own property, and to receive equal justice. The separate part was rigorously enforced. The equal part was a complete and utter fiction. The court's decision didn't just permit injustice, it actively licensed and encouraged it on a massive scale. These historical blunders are not dusty relics of the past. They are the direct ancestors of the legal problems we face today. The same mindset that produced Plessy, the willingness of a court to ignore the plain meaning of the law to achieve a desired outcome, is what allows a state to prosecute a citizen in its own court system. It's a philosophy that prioritizes state power over individual rights. Tanawa Downing's argument connects these dots, showing that the fight against a state acting as its own judge is part of the same long struggle against a judicial system that sometimes chooses convenience and power over the hard, necessary work of ensuring true justice for all. In the dark history of cases like Plessy v. Ferguson, there is often a single, heroic dissenting voice that cuts through the darkness. In this story, that voice belonged to Justice John Marshall Harlan, while his 8 colleagues...
Now, the other video back on talking about the going to the Fifth Circuit, right? He did bring that up in his document. Marshall, okay? He's the lone wolf, okay?
Supreme Court were busy contorting logic to justify segregation, Harlan stood alone as a beacon of reason and moral clarity. His lone dissent in Plessy is one of the most powerful and prophetic documents in American legal history. He was the one good man who refused to do nothing while evil triumphed, the one person in the room brave enough to call out the emperor's new, very racist clothes. Harlan's argument was simple, elegant, and devastatingly correct. He argued that the majority had missed the entire point of the Civil War amendments. He saw segregation for what it was, a system designed to perpetuate a racial caste system, a badge of servitude wholly inconsistent with a free society. And then he wrote the immortal line that should be carved above the entrance to every courthouse in the nation. Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. It was a direct, powerful rebuke to the prejudice of his time. What makes Harlan's dissent even more remarkable is that he was a former slaveholder from Kentucky. He was a man of his time, but he was able to rise above the ingrained prejudices of his background to see a more profound constitutional truth. He understood that a government of laws required him to put aside his personal history and apply the principles of the Constitution fairly. His transformation shows that fidelity to the law is not just an intellectual exercise, it's a moral commitment. He chose the hard path of principle over the easy path of conformity, and for that, he is remembered as a judicial hero. Tragically, Harlan was a lone dissenter, not just in Plessy, but also in another crucial case, Hurtado v. California. In that case, the same 8 justices who endorsed segregation also ruled that states were not required to use a grand jury indictment to prosecute someone for a serious crime, chipping away at a fundamental protection in the Fifth Amendment. Harlan saw the connection. He understood that a court willing to strip away rights based on race would be just as willing to strip away other fundamental procedural protections. His lonely dissents remind us that being on the right side of history sometimes means standing by yourself, and his courage continues to inspire modern-day fighters for justice like Tanawa Downing.
Now, this our nation obviously has bad things in its past, but recognize that slavery may have had freedom to a certain level and released, but in exchange, it downsized everybody else as well. the whites was down status and all that kind of stuff. There's a reason why you hear people correcting their status and all that. Well, it's because, and don't get mad at me, I'm just kind of giving a little word in there, right? If the white people was way up here and the dark was way down here, well, what they did is meet in the middle. So the white people lost their rights and black people gained a little rights, piece at a time, one piece at a time, but they never truly, ever gained all the rights. As white people have full rights, but they got down status. So we're maybe in an equal playing field, but it's because you went not fully freedom, and then the white people lost freedom. Is the way I see it, okay? And it's not good, okay? Again, this is what our courts have done with us, all of us.
Now let's talk about something that sounds technical but is incredibly important: the grand jury indictment. The Fifth Amendment to the Constitution states, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury." This isn't just legal jargon, it's a powerful shield designed to protect ordinary citizens from the immense power of the government. It means that before the state can drag you through the mud of a criminal trial, it first has to convince a jury of your peers that it has enough evidence to even bring a charge. Think of it like this. Imagine you go to a very fancy, very expensive store. You browse around, but you don't buy anything. As you're leaving, the store manager stops you and says, "You owe us $10,000. You'd be confused. You'd say, "For what? I didn't buy anything. Where's the bill? Where's the receipt?" The manager just shrugs and says, "You were in the store, so you owe us. Now pay up or we're sending collections after you." That sounds insane, right? You would demand to see a bill, an itemized list of what you supposedly bought before you even considered paying a charge. In the legal world, the grand jury indictment is the bill, and the criminal complaint filed by a prosecutor is the charge. The Fifth Amendment says you must have the bill before you can be hit with the charge. The grand jury, a group of regular citizens, acts as the auditor. They review the prosecutor's evidence in secret and decide if there's probable cause to believe a crime was committed. If they agree, they issue an indictment, the bill.
And a little bit ago, I did talk about how they give themselves qualified immunity deal, and I believe it was on the Fifth Circuit Appeals when I brought that up. But the here and now, they have shielded themselves so much that it is actually legal for the prosecutor to lie to the grand jury. Now, how is that true justice? And when you catch them in that lie and you call them out and all that kind of stuff, what does the courts do? Oh, they got qualified immunity.
Process prevents prosecutors from filing bogus, harassing, or politically motivated charges just to ruin someone's life. It's a crucial check on government power. Yet, in the case of Hurtado v. California, a decision opposed by our hero, Justice Harlan, the Supreme Court ruled that states didn't have to follow this part of the Fifth Amendment. This decision effectively ripped the shield out of the hands of millions of Americans. It allows state prosecutors to bypass the grand jury and file charges directly, a process known as information. This is like the store manager being able to send you straight to collections without ever having to produce a bill. As Tanawa Downing argues, this isn't just a procedural shortcut, it's a form of fraud. It creates a debt, the criminal charge, without the necessary paperwork, the indictment, to prove it's legitimate. This brings us back to the core of the problem, the legal paradox that sounds like a riddle from a fantasy movie. What happens when a state is a party in a case? Who gets to be the judge? The answer, according to the plain, simple text of the U.S. Constitution, is crystal clear. Article 3, Section 2 lays it out in black and white. In all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. It doesn't say the Supreme Court might have jurisdiction if it feels like it. It doesn't say state courts can handle it first. It says the Supreme Court shall have original jurisdiction. This wasn't an accident or a typo. The framers of the Constitution were brilliant, and they were also deeply suspicious of concentrated power. They understood that allowing a state to judge its own case would be a disaster for justice. James Madison, one of the primary architects of the Constitution, addressed this very issue in the Federalist Papers. In Federalist Number 10, he wrote, "No man is allowed to be a judge in his own cause, because his interest would certainly bias his judgment, and, not improbably, corrupt his integrity." It's one of the most basic principles of natural law and fairness. So if no man can be a judge in his own cause, why on earth would we allow a state, a massive, powerful entity with a huge interest in winning, to be the judge in its own cause? It makes no sense. When the state of Washington prosecutes one of its citizens, it is a party to the case. For that case to then be heard in a Washington state court, presided over by a judge who is an employee of the state of Washington, is a glaring violation of this principle. The state is acting as prosecutor, judge, and jury, which is about as fair as a football game where one team also gets to be the referee. This constitutional command for Supreme Court jurisdiction is not about disrespecting state courts. It's about ensuring impartiality. The framers knew that to create a truly fair system, you needed a neutral arbiter for disputes involving the states themselves. They designated the U.S. Supreme Court as that neutral ground, a forum where a citizen and a state could face each other on a more level playing field. Ignoring this clear constitutional directive, as has been done in countless cases, is not just a legal error. It's a betrayal of the framers' vision for a just and balanced republic. So, why is it so critical that the U.S. Supreme Court, and only the Supreme Court, hears these cases? It boils down to one word: fairness. The entire structure of our government is built on a system of checks and balances designed to prevent any one branch or level of government from becoming too powerful. The requirement for the Supreme Court to have original jurisdiction in cases involving a state is a crucial part of that design. It is the ultimate check on a state's power, ensuring that when a state goes to court, it does so as a participant, not as the master of the entire proceeding. When a state prosecutes a citizen in its own courts, the scales of justice are inherently tipped. The prosecutor is an agent of the state. The judge is an employee of the state whose salary is paid by the state. The court system itself is funded and operated by the state. The citizen, on the other hand, stands alone. To pretend that this is a fair fight is ludicrous. It's like asking a mouse to enter a boxing ring with a cat, where the cat is also the referee and the timekeeper. The outcome is predetermined. Remanding cases like Tanawa Downing's to the Supreme Court is not a radical idea. It is a call to return to the original, intended meaning of the Constitution. It is a demand that the system work the way it was designed to work. The Supreme Court is meant to be the one place in our legal universe where power is held accountable to the law. It is supposed to be above the political fray of any single state, capable of rendering a judgment that is impartial and binding on all parties. This is essential for maintaining trust in our legal system and for upholding the rule of law. This isn't about letting people off the hook for crimes. It's about ensuring that the process of determining guilt or innocence is fundamentally fair. If the process is corrupt, the outcome is meaningless. True justice can only be delivered in a forum free from bias and conflict of interest. For cases where a state is a party, the Constitution explicitly names that forum the Supreme Court. Honoring that mandate is the only way to guarantee that every citizen gets what they are promised. Not a guaranteed win, but a truly fair fight under the law.
Moreover, y'all, sit and think about this. What kind of sicko, whether you're state, Congress, senator, judge, attorneys, officers, why would you want your own family members to be enslaved to the state? Sit and think about that. I don't even think they think about their offsprings all being enslaved by their orders or laws or statutes or anything like that. Again, we talked about it. If I can get a ticket by walking across the street. That's not freedom, that's enslavement. Period. And don't say, oh, it's for your safety. The Supreme Court already said that it's not the officer's job for your safety. And yet they just keep coming back to safety. Well, did they or did they not actually have a conflict? Right? Officers for your safety. Well, now officers not for your safety. Well, officers for your safety. Well, officers not for your safety. Which is it, courts? Which one?
We began with a warning about what happens when good people do nothing. The story of Tanawa Downing's fight for justice is the story of someone refusing to do nothing. It is a courageous stand against a system that has, through a series of flawed judicial philosophies and a neglect of clear constitutional text, become fundamentally unfair. It is a call to correct a structural flaw that allows states to act as the dealer, player, and referee in a game where a citizen's liberty is on the line. This fight is not just for one person, it's for the integrity of the entire American legal system. The path forward requires us to embrace the principles championed by heroes like Justice John Marshall Harlan. We must insist that our Constitution is colorblind and more broadly class-blind. We must demand a government of laws, not of men, where the rights enshrined in our founding documents are not negotiable talking points but solid, unbreakable promises. This means restoring the vital protection of the grand jury indictment as a shield against prosecutorial overreach and insisting that the U.S. Supreme Court fulfill its constitutional duty as the neutral arbiter in all cases where a state is a party. This is not a partisan.
And moreover, our simplified, very simple thing, our due process, that they are completely ignoring. And they're all got qualified immunity to violate your due process. That's what the due process is, the grand jury. The grand jury, without that due process, cannot exist. Diesel, We the People News. Bye, y'all.